who wanted to take away the employment opportunities from the Chupanqui community, but that it was their own decision out of a general assembly held by the Chupanqui community to try to veto the project, and therefore it is only clear that the members of the Chupanqui community would not like to cooperate any further with the project. It is also clear that since the Chupanqui communities make up for the largest number in the workforce of the Turbo Water Company, that the working force must be replaced. Otherwise, this would cause a huge lack of manpower. On a second point, the states would like to stress that the employment opportunities are only one of several items in the benefit sharing package that has been given to the Chupanqui community, as well as larger extension of lands of equal agricultural quality, water wells, electricity, a direct road, and also computers. And therefore, even if the employment opportunities have been forsaken out of their own free will too, that doesn't mean that the whole package can be seen as valueless or that the whole package has decreased.
Councillor, do I understand you right that you view the Black Swan Dam construction as a private enterprise, not a state enterprise?
Could you please repeat the question, Your Honor?
Do I understand you right that you argue that the construction of the Black Swan Dam and the corporation that does so, the joint venture, is basically a private enterprise?
Thank you, Your Honor. The Turbo Water Company is, in its majority, a private enterprise. The state of Atlantis holds a purely capital share within the company of 40%, and the building of Black Swan is and can be seen as a private enterprise.
Okay. Now, under those circumstances, may I draw your attention to the jurisprudence of this court and other courts on a second level of obligation when it comes to consultations, namely in case of conflict. If there is a conflict between a private enterprise and an indigenous community in the midst of a project that is ongoing, the duty to consult arises again. Has your government consulted at that stage?
Thank you, Your Honor. What it is clear is that the Chupanqui community was consulted and that the government of Atlantis, through the Intersectoral Committee, obtained their consent. In the second step of the project, while the construction is in the middle of it, in the second phase of stage of it, the Chupanquis decided no longer to work for the Turbo Water Company. However, it is only clear that while their consent has been obtained, they should no longer be able to stop the project because of their unhappiness or because of their allegations regarding the labor conditions, and therefore the consultation process was correct and was fulfilled. And whether or not the Chupanqui communities have issues with the Turbo Water Company, those are issues that should be brought in front of the labor authority.
But your co-counsel brought up the employment as one element of the overall benefit sharing. If that element falls away, does not part of the agreement fall away, and therefore the consultation process needs to start again?
Thank you, Your Honor. The consultation process, as my co-counsel has said, is a dialogue. But it is clear that the consultation process was fully conducted, and not because one part of the whole benefit package falls away, it means that the whole process should be renegotiated. In principle, it could be seen as acceptable to maybe renegotiate the labor issues within between the Turbo Water Company and the Chupanqui community, but that is something that should be referred to the labor authority. I would like to turn now to the issue of Article 21.1, that is the right to property of the peasant farming community of La Loma. As this court has established in the case of Chiriboga v. Ecuador, the right to property under Article 21 is not absolute and can be subject to limitations. it is clear that the state of Atlantis did not violate the right to property of the dissenting property owners of the La Loma community. With regard to the first requirement, it means that the limitations must be previously established by law, they need to be necessary, they need to be proportional, and they need to be with the aim of achieving a legitimate aim in a democratic society. In the present case, the Article 4 of the Civil Code of Atlantis allows for expropriation procedures to take place. It is necessary not only to build it in the place where it will be built, but also because of the current energy crisis, the high levels of poverty and social exclusion, and with the aim of producing clean and green energy.
How has this court determined or defined necessity, and how would you apply that definition to our fact?
The necessity has been determined by this court as, for example, in the case of Salvador Chiriboga v. Ecuador, that there must be an imperative public need. The imperative public need is present in the present case due to the fact that Atlantis is highly dependent on foreign energy sources. Energy prices have jumped. Furthermore, there is constant blackouts in the cities, and there is high rates of poverty and social exclusion in the eastern part of the country, and therefore it is absolutely necessary to build Black Swan. I would like to turn now to the issue of proportionality, which is clear that the relocation of the La Loma was proportional, since there was no other means to interfere less with the right to property. There has clearly a legitimate aim in a democratic society, which is eradicating poverty, producing clean energy, and improving the electrical power for the whole nation.
But, Counselor, aren't you moving them to temporary camps where they live in fairly poor conditions, and you're taking them away from the river? So wouldn't you also say that, how can you say that something which almost amounts to a violation of Article 5.1 could be proportional?
Thank you, Your Honor. First and foremost, the state would like to point out that the temporary camps are exactly that, temporary. They are only meant to be there for a very short period of time until all legal issues have been settled. Furthermore, it is proportional because there are no other means to interfere less with the exercise of their right to property, due to the fact that their lands will be either flooded or used for the construction works, and therefore keeping the community in its current place would be a hazard to their lives. There are very serious security issues in the construction of a dam that need to be considered, and therefore moving them only 25 kilometers away from their actual place of residence is the only possible way that the state of Atlantis has to interfere the less with their exercise of their right to property.
Couldn't they just not flood the lands? Wouldn't that be the way that interferes the least?
Thank you, Your Honor. No, unfortunately not. It is necessary to build Black Swan, and it is also the prerogative of the state of Atlantis to do and build certain projects that will raise the standard of living of the whole nation, and it is necessary to have a small relocation of only 25 kilometers in order to ensure the construction of the Black Swan Turbo Water Company and of the Black Swan hydroelectric power plant.
Is it your opinion as a state, though, that then the treatment of the Loma community in the temporary camps does not amount to a violation of Article 5.1?
No, Your Honor. The poor living conditions, as has been clearly said in the question and answers, does not constitute a violation of Article 5.1, since that has never reached the threshold as established by this court in the Moiwana massacre, where people were forced at gunpoint to get out of their village. They were never able to bury their death, and therefore both situations cannot be compared.
But, Counselor, I don't remember in that case that we established a threshold, meaning that you must have this level of severity in order to be considered a violation of Article 5.1.
It is true, Your Honor, that this court has not established a precise threshold for mental and physical damages. However, bearing in mind all the cases in which a violation of Article 5.1 has been found, as in the case of Moiwana v. Suriname, it can only be seen as reasonable to deny a violation of Article 5.1 in the present case. Your Honors, as I see that as my time is running out, may I please briefly conclude? To conclude, Your Honors, the State of Atlantis respectfully requests this court to establish that the respondent State of Atlantis did not violate Article 5.1, 6.1, 6.2, 5.1, 21 and 25 of the Convention. Furthermore, the State of Atlantis respectfully requests this Honorable Court to reject the provisional measures asked by the Commission and allow the continuation and conclusion of Black Swan's construction.
Counsel, a quick question. If we would find a violation of any of the provisions of the American Convention on Human Rights in this case, is it our power also to order the termination of the project and the restitutio in integrum, as we call it in Latin?
Thank you, Your Honor. It is the power of the court to reject the provisional measures asked by the Commission, and therefore the State of Atlantis would be able to continue to build Black Swan.
Yes, but if we find that you cannot, can we then order you? Is it in our prerogative to order you to stop the project and to rebuild the land as it was prior to the intervention?
It is the other understanding of the State of Atlantis that this court has the power to issue provisional measures by which the State of Atlantis would see itself in the position to stop the project, and whether or not the whole project should be taken back or everything should be pulled away, that is a completely different issue for which I have no clear answer at this moment, Your Honor. To enable the State of Atlantis to secure the relocation of the Chupanqui community as agreed between the indigenous community and the state according to their own customs and traditions, and to establish that the consultation procedure the Chupanqui community fulfilled all international standards of free, prior, and informed consent, and that fair compensation was offered to their members. Thank you so much, Your Honors.